In North Carolina, you generally cannot move with your child across the state or out of it without the other parent's consent or the court's approval if a custody order or agreement is in place. Moving first and asking later is the single most damaging mistake a relocating parent can make. This is for both sides, the parent who needs to go and the parent watching the truck get loaded. It depends on what governs your custody arrangement right now. There are 3 possibilities. If a court order governs custody, you must either get the other parent's genuine agreement, formalized through the court, or file a motion to modify the order before you move. Relocating in violation of an order can put you in contempt and hand the other parent a powerful argument to change custody. If a separation agreement governs custody, that agreement is a contract. Moving in a way that breaks its terms is a breach of contract, and the other parent can sue to enforce it. To change those terms, both parents must agree in writing, or one of you has to file a custody action and ask a judge. And if no order or agreement exists, both parents have equal rights to physical custody until a court says otherwise. You have more freedom, but not unlimited freedom. A move that looks like an attempt to escape North Carolina's courts can trigger an emergency order bringing your child back. One more thing, having primary physical custody does not give you an automatic right to relocate. Primary custody describes where your child mainly lives. It is not a license to change that arrangement on your own. Before you accept the job, sign the lease, or tell the kids, work through these in order. Read your custody order or separation agreement, every word. Many contain geographic restrictions, a mileage radius, a county limit, written consent before any out-of-state move, notice provisions. What your document says controls what happens next. Be honest about why you're moving and what your child gains. Judges look for moves that benefit the child, not just the parent. If the honest answer is this move is for me, you will need to show how your gain becomes your child's gain. Talk to your co-parent early. An agreed relocation with a schedule the other parent helped build is faster and far less painful than a contested hearing. Courts notice which parent tried to cooperate. Put any agreement in writing and formalize it. A handshake is not protection. And talk to an attorney before you commit to the move. The order of operations matters enormously here. If a custody order is in place and your move would break its terms, you need formal agreement or court approval first. Here is what moving anyway risks. Contempt of court, which can mean fines and, in serious cases, jail, and which starts your case with the judge already seeing you as the parent who broke the rules. Emergency custody entered against you. A court can enter an order without you in the room where a child has been removed from North Carolina to evade its jurisdiction, an order to bring your child back. Under the interstate custody rules, North Carolina keeps jurisdiction even after a wrongful removal, and the court can order the child returned. And losing the case, you would have won. Unilateral moves read as putting your interests ahead of your child's relationship with the other parent. That is the exact opposite of what a relocation case requires you to show. The exceptions are narrow. Courts understand true emergencies. A parent fleeing domestic violence with a child can and should get to safety first and get to the courthouse immediately after. You file a motion to modify custody in your existing case, and the judge has to find 2 things. First, a substantial change in circumstances affecting the child's welfare since the last order. Second, that the change you're asking for is in the child's best interest. And here is the wrinkle. A proposed move is not automatically a substantial change in circumstances. Our appellate courts have made clear the relocation has to be evaluated for its effect on the child. A move that meaningfully changes your child's life, schooling and access to the other parent can qualify, but the judge has to be shown why. Practically, you file the motion, you attend mandatory custody mediation, unless it's waived, and if mediation doesn't resolve it, both parents testify at a hearing where the judge decides whether the move happens with the child. Build in time. These cases rarely resolve in a few weeks, so start well before your intended move date. There is no formula, no presumption for or against moving. The judge's North Star is your child's best interest, and our courts have identified factors that guide the analysis. The advantages of the relocation for the child, not for you, for the child. Better schools, a safer neighborhood, supportive extended family, financial stability that actually reaches your child's daily life. Your motives for moving. A genuine opportunity reads very differently than a move designed to put miles between your child and your ex. the likelihood you will honor the new visitation schedule. Your track record matters here. The other parent's motives for opposing, genuine concern about losing the relationship carries weight, opposition rooted in control does not, and whether a realistic schedule can preserve your child's relationship with the parent staying behind. This is often the heart of the case. Judges also weigh the everyday texture of your child's life, age, school, and community ties, siblings and grandparents, and for an older, mature child, the child's own preference. Enormously, the court will ask why you are moving and then trace how that reason reaches your child. A better job is often the strongest ground, but the connection has to be drawn, not assumed. More income that improves your child's home, better hours that mean more actual parenting time, real career stability, a modest raise that costs your child their weekly time with the other parent is a hard sell. Show the math and show the schedule. Moving closer to family. Judges understand the pull of grandparents and a built-in support system. But the analysis is two-sided. What does your child gain in the new town and what do they leave behind? Marriage or remarriage? Remarriage alone is not a substantial change in circumstances. What can carry the day is what the new household offers your child: stability, security, a good home, and a good school district. And candidly, your own education is usually the least persuasive ground on its own. If your ex wants to move with your kids, you are not powerless, but do not wait. If an order or agreement is in place, your ex has to go through the process we just described before moving. You have the right to object, and the court will scrutinize the move under those same best interest factors. Focus your case on the child, not the fight. The most persuasive left-behind parent shows the court a rich, specific picture. The Tuesday practices you coach, the homework routine, the school your child loves, then shows why distance breaks it in ways a summer-heavy schedule cannot fix. Check your own record too and move quickly, because waiting until the boxes are packed narrows everyone's options. If your ex already left without your consent, the remedies are real, but they reward speed. Where an order governs, you file a motion for contempt. Where an agreement governs, the move is a breach of contract, and you can also file a custody action. And if your ex left the state to escape the court's reach, ask about emergency custody and interstate enforcement. Document everything from day one. Relocation cases are the hardest in family law. Nobody is arguing about money. Everyone is arguing about time with a child, and geography makes compromise genuinely difficult. They are also the cases we know best. At McCrary Pack, we wrote the book on child relocation in North Carolina, and we have guided parents on both sides of these cases for years. Family law for Iredell, Catawba, Alexander, Caldwell, and Burke counties, where clients are neighbors, not numbers. Thinking about a move or staring at an empty bedroom? The full guide is linked below. Reach out today.